Now to introduce the two of us. Firstly, we've got Kirsty here, who is a partner in Gallie Miles. She's based here in Te Awamutu. Kirsty is a solicitor who practices all things good in the law and some of the bad stuff as well. I'm Alistair Flatt. I'm a chartered accountant and a business advisor. I work here in town for Crowe Horwath, and I'm the Te Awamutu principal. Now, let's get the show on the road. Kirsty.
Thanks, Alistair. Before we start, I just want to quickly introduce some other members of the Gallie Miles team who are also here today. We've got Linda Miles sitting towards the rear, Valerie Mackay, who are my two business partners, and one of our senior solicitors, Stacey Hayes, who's also right at the very back. So the Gallie Miles team are here to, if you've got any questions or you want to talk to them afterwards, we'll stay around for a few minutes and have a chat. If, as we're going through today, you have any questions that you want to ask, we'd like to do a kind of question and answer session at the end. So in your packs that you've got, there is note paper, you've all got pens, so if you have any questions that occur to you as we go through, if you could just note them down and we'll take questions at the end. I want to start today by telling a story, and it's a story about Bob, who is a client who came in to see me fairly recently. Bob's in his mid-60s. He'd been married once before when he was in his early 20s, and that marriage ended in his 30s. When he was in his 50s, he met Melanie. Melanie was 15 years younger than him, and Bob couldn't believe his luck to have found love again at a later stage in life and with this beautiful younger woman. Between the end of his first marriage and when he met Melanie, Bob had inherited the family farm. And the farm had been in his family for about 4 generations. Bob and Melanie married, and after their marriage, Melanie moved into the farmhouse onto the farm with Bob. Bob talks about Melanie as having been a good, honest Christian woman who he trusted, and to the extent that they ever talked about the farm and who owned the farm and what was going to happen to the farm, he says that Melanie said, "Look, it's your farm, I'd never take it from you." After their marriage, they initially both worked together on the farm, and then Melanie soon fell pregnant and they ended up having 2 children together. It's probably fair to say that life was pretty tough for Bob and Melanie. There wasn't a whole lot of money, and what money they did have was invested in the farm. They spent money putting in new milking sheds, races, fences, and investing in the property. Unfortunately, and I suspect you all know how the story is going to end, Bob and Melanie have now separated, and Melanie's making a claim for a half share in the family farm. Bob, because of his age, is in a position where he's not going to be able to borrow money, he's not going to be able to buy her out. The farm has a value of, say, around $3 million. And he's now facing the very real prospect that he will have to sell the family farm in order to pay out Melanie for up to a half share of its value. Bob is devastated. He feels like he has let down his parents, his grandparents, and he feels like he's let down his own kids too, because he's not going to be able to pass down the farm that's been in his family for generations. So what we're going to do today is we're going to try and take you on a little bit of a journey. And along that journey, we want to try and identify some of what I like to call relationship property traps that lie in the road. And then we want to try and identify some ways that you can protect yourself against some of the risks that those traps pose. So with the idea that you can avoid finding yourself in a situation similar to Bob. And we'll also, towards the end, just have a look at some of the issues that are particular to people who are in a blended family situation, or perhaps in second time or third time relationships. I'm going to start by doing a very brief, very general overview of the law. And I think it's important just to put into context what it is, the types of things we're going to talk about as we travel along the road. Property relationship law is governed primarily by the Property Relationships Act. And under the Act, there are two different types of property. There's separate property and there's relationship property. If an asset is deemed to be relationship property, then it's going to be subject to a 50-50 division on either separation or in the event of the death of one of the partners. 50-50 split applies to married couples or to de facto couples who've been living together for 3 years or more. In very general terms, property that you own before the relationship starts is separate property, and property that is acquired during the course of the relation is relationship property. And the really important point that I want you all to come away from today is that property which is separate property at the beginning of your relationship can become relationship property during the course of your relationship and then is subject to a 50-50 split. So the first most common relationship property trap that people might find themselves falling into is in relation to the family home. The house that you and your partner live in will be relationship property regardless of who owned it at the beginning of your relationship. And so a really common scenario might be a couple meet, perhaps it is a second time round relationship. She owns her house, he owns his house. Relationship goes well and they think, well, we'd like to take this to the next step, let's move in together. And they decide that because her house is perhaps closer to where they both work, closer to their friends, they'll live in her house. And he says, well, I'll rent my house out, or maybe he says, I'll sell it. They move into her house, the relationship continues for a while, and then after 4 or 5 years it comes to an end, and she is shocked to discover that the house that she thought was her house at the beginning of the relationship has become relationship property, and he's entitled to a 50% claim in its value. His house, which he's rented out, or perhaps the money that he got from his house, is probably still going to be separate property, and so he still has that as his sole entitlement. One of the many wonderful things about relationship property law is there's lots of grey areas. And so a couple can be deemed to be living together in a particular house, even if they don't live together full time in that house. So it's entirely possible for a couple to have two separate houses which they both spend time in, but at the end of the relationship, if it were to go to court, a judge could find that one of those houses is relationship property. So an example of that was a client that we had come into the firm who was older and had a property that was close to Hamilton. He had a friendship with a woman who had her own house. She had a number of health concerns, so she would often come and spend time at his house so that she could attend appointments, have procedures carried out like at a hospital. The friendship came to an end. She made a claim on his property saying that it was relationship property, it was their family home, and in that particular case the court agreed with her and found that it was indeed their family home, and it was subject to a division. Business assets can also be at risk. If you have a business at the start of your relationship, and the farming scenario is a very common one, and if you want to think back to Bob's situation, one person owns a farm, they meet somebody, they get together, partner moves on to the farm, they might start working together on the farm. Those business assets are at risk if your partner is working in your business, if relationship monies, i.e. the income that's being earned, what is being used to support the business, or indeed even if your partner is at home raising your children and freeing you up to build and grow the business. Those are all circumstances which can give rise to a possible claim. Cars and other chattels also can be at risk, so again, fairly common scenario, two people meet, they've both got their own cars, one's a particularly expensive looking car, and And they will both probably regard those cars as their own cars. But if one of those vehicles is the vehicle that gets used going to the supermarket, taking the kids to sports, when they go on their holidays together, all of those things, because those assets are being used for a relationship purpose, can convert the car, the vehicle, to a relationship property asset and can make it subject to a 50-50 split. Gifts and inheritances. This is a really, really common scenario that we come across. If during the course of your relationship you receive an inheritance or you receive a gift, that will be your separate property, but only as long as you keep it separate. Common situation we see is you've got a couple, they've been married for a few years, they own a house, they've got a mortgage. Great-grandma dies. She leaves the husband $100,000 in her will. He says, fantastic, this is great. We can use that to pay off the mortgage. We'll be mortgage-free. Isn't life good? Unfortunately, the marriage comes to an end a few years later, and they're sitting around dividing up their assets, and he says, well, hang on, that $100,000 that I got from great-grandma, that's mine. No. Under relationship property law, because that money's been used for a relationship property purpose, it goes into the pool to be divided up 50-50. Another fairly common scenario is where you have a young couple, they've been together for a few years, they've been struggling to save up for their first house. Her mum and dad say, well, look, we want to help you out. Here's $30,000 to use to help you out with the deposit on the house. Buy the house, the relationship continues, but again, sadly, it comes to an end after a few years. And mum and dad say, well, hang on, you should get back that $30,000 that we gave you for the deposit, that's yours. No. That money, because it's been used for a relationship property purpose, is relationship property subject to a 50-50 split. Really easy way of protecting against that particular risk is to go and see your lawyer, spend a few $100s, get it drawn up so that there's a deed of acknowledgement of debt, it's recorded as a loan, repayable on demand, and which means that instead of being a gift, it's a loan, and if the relationship does come to an end, that money can be pulled out of the relationship property pool.
Okay, my turn. What happens is when you've got relationship property and you're trying to solve some of these issues going forward, we want, as accountants, to put structures around them and do bits and pieces. So we have things called companies, we have trusts, we have partnerships. They're all part of the process of what we want to do it. But it's not only relationship property that we're dealing with. We've got to look at other things as well. Ooh, I'm pushing the wrong button. So you've got to look at the risks of your business and around what you're trying to protect. So it's not only relationship property you're trying to protect, you're also looking at business risk, you're looking at the lovely stuff like Environment Waikato, Work and Safety New Zealand, all of those things come into the risk pool. We've got to get tax effectiveness, because what we don't want to do is pay tax on $400,000 on one side, and on the other side create a loss of $200,000 and not be able to offset it. So we've got to look at those type of things as accountants. We do property protection, so that's around looking at protecting that property, not only for you, but it might be for your family or for someone else that's coming in. We've got child support, that rears its head, so we've got to deal with that and work that through. Okay, ACC is another issue. It's how we allocate the income and deal with it from there, that point of view. And there's other things like student allowances, student loans, family assistance, rest home subsidies. All of those things have to come into the pool. So we look at things globally, not just specifically for one item. So that's what we've got to do as accountants, and we work with our lawyers to make sure that we're getting the most effective plan for you. What I've learned over the years is you can't just go and look it up in a book and say, this is what will work. You've actually got to listen to what you guys want and then decide what is the best for you.
So what Alistair's saying is right. A global approach does need to be taken, and trusts and company structures can offer protection against a relationship property claim. But they can be challenged. In order for those structures to offer the best possible protection for you, they ideally need to have been in place well before the relationship started. There must be genuine reasons for those structures to be put in place, and they must be operated properly. So for example, if you've got a trust and it's owning the house that you live in, then you need to make sure that you are having trustee meetings, resolutions are being passed, minutes are being kept. Because if those structures are found to be a sham, or if those structures are found to have been put in place in order to avoid the provisions of the Property Relationships Act, then they risk being set aside. The very best protection that you can get is a contracting out agreement, or what some people sometimes refer to as a prenuptial agreement. And a contracting agreement is when two people sit down and they say, yes, we know that under the Act we could get 50-50 split if this all turns pear-shaped, but that's not right for our situation. We want to do something different, and we want to contract out of the provisions of the Act and make our own arrangements. For a contracting out agreement to be effective, it must comply with the provisions of the Act. It's no good for a couple to sit around the kitchen table, get out a piece of paper, write down what they think they want, sign it and put it away in a drawer. If you separate, that is not going to give you any protection. To be effective, a contracting out agreement must be in writing. There must be full disclosure of all assets that both parties own, and both of the parties must get independent legal advice. And that's to make sure that both parties fully understand and are aware of the rights that they're giving up and what the nature of the agreement is that they're entering. So it's there to protect both parties. We recommend that if you have a contracting out agreement, it's either drafted to be flexible so it takes into account changing circumstances, or even better that you sit down and you review it at least every 5 years. Because as your relationship changes, as your circumstances change, you may have a family, you may start off with very few assets and you may end up with significant assets. As those circumstances change, the agreement needs to still be fair and equitable, because a court will overturn an agreement that isn't fair and equitable. And there's a recent case where a couple entered into a relationship property agreement. At the start of the relationship, there was fairly modest business assets, and under the contracting out agreement, I think from memory, it provided that the wife was going to get $30,000. They were together for about 15 years. Over that time, the husband's fairly modest business became a significant multi-million-dollar enterprise. And the court said at the end of, and he turned around and said, "Oh, sorry, honey, it's been great, but here's your $30,000, I'm off." And the court said, no. That agreement is no longer relevant for your particular circumstances. It's no longer fair and equitable. We're going to overturn it. So the best protection that you can have is a contracting out agreement which is reviewed on a regular basis and is flexible to take into account changing circumstances.
What a subject, yeah. What happens is, if you don't plan for the future, someone will plan it for you. So you need to make sure that you do certain things and have what we call a succession plan. There is always a future, don't ignore it. Succession allows you to plan for who gets what and when. It's a whole lot easier to do it while you're alive, because you don't want your children and their spouses, or your grandchildren and their spouses, trying to work out how things are to be dealt with. And it's not only spouses and children of you, it also it's spouses and children of your new partner and how you deal with it going forward. Because if you want to have a family war, don't do anything. Okay? Items to think about are who has the control and who is to get the wealth. So those are the things you need to think about, but you need to have a plan. It's very important.
There's two important points I just want to make around death and relationship property in particular. The first thing is that, I don't know, a lot of people are unaware, but if you have a will and your will makes provision for your partner in the event of your death. Your partner or spouse can challenge or has the option after your death of electing to effectively challenge your will and say, yes, I see that you've given me a life interest in the house and that's wonderful, but in fact I'm entitled to 50% of the relationship property assets and that's what I'm going to claim. So if you don't make adequate provision in your will, then it could be subject to a challenge by your spouse. The only protection that you have, or the best protection that you have against that scenario, again, is the contracting out agreement, which has effect on both separation and in the event of your death, to prevent those kinds of challenges from happening. And the other really important point is that if you have separated from your partner, you must get a new will. Because if you don't, the provisions of your will still have effect if you're married up until the date, up until the gifts in your will up until the date your marriage is dissolved. So it's really important, if you've separated and you don't want the provisions in your will to apply, you don't want your ex-partner or spouse to receive the assets they would have received, you must get a new will signed. I just also wanted to talk about particularly succession planning for blended families, because blended families throw up some really complicated and complicated issues. Often with blended families, you've got his children, you've got her children, and sometimes you have their children. And how do you make sure that the asset pie is being divided fairly? What if one of you brought more assets into the relationship than the other one did? Do your kids have to share with their kids? What happens if you die first and you leave all your assets to your partner? Will she or he provide for your children? What happens if he meets someone new and repartners? Are your kids going to be left out completely in the cold? So there's a whole range of different and difficult issues that can arise, particularly in a blended family situation, to make sure that the solution that you put in place is going to be effective, it's going to withstand any kind of challenge. Can you say something about trust?
When we were preparing for this, we had that photo of the Brady Bunch. And for those that can remember the Brady Bunch, now I looked at the photo and I said, look, you've got the girls on one side, you've got the boys on the other side, but who's in the centre? It's the housekeeper. What's going on there? But that's what relationship property is about. It's about all the relationships that you actually are in and looking at where you are going and how you want your pie to be done. There's also the case where you might die, but your new partner, yes, she gets the opportunity to have the assets, but then where do you want those to go? Do you want them to go to the right people? So it's all about planning.
And I guess we've got just a note about trusts up there. I mean, trusts are one part of that succession planning conversation, and they have the advantage of providing flexibility and different options for different kinds of scenarios. So again, it's about communication, it's about talking with your partner, it's about agreeing how you want things to be, and then making sure you put in place the right structures and the right documentation so that they'll have effect.
Or the good old child support. Ideally, what you want to do is be able to work out an agreement with your ex so that you can get it dealt with. The fallback, however, and not many can get it sorted with their ex, but the fallback is the Inland Revenue sit in the gap and they have a formula on how they work out child support. What has been happening is child support's been around for a reasonable length of time. They've done a big review of child support, and over the next 3 years there's quite significant changes happening with IRD and how they calculate the formula. Now the base is still the same, but there is a lot of things that are changing around the base, and some of that stuff happens now. Some of it happens next year, some of it happens the year after. And what you need to do is, if you're in that position, please go and have a look at the website at IRD, and you'll see a button to click on that says changes, and those changes are all noted there. The big thing about child support is everyone's circumstances are slightly different, and you've just got to work your way through the formulation to work out where you're at.
I was just going to say there's a really good calculator on that website as well, so you can put in your information and it will calculate what your child support entitlement and liability will be once the changes have effect. So just in conclusion, I think the key points that I would really like people to take out of today is really around communication. It's really important. These are really difficult issues for people to talk about, but it's important that you do communicate with your partner, you talk about and you have a conversation about what it is that you want, and then you talk with your lawyer, you talk with your accountant to make sure that you put in place structures and agreements that mean that you're going to have the outcomes that you want. And the most important thing is that you do need to have a plan, because unfortunately the reality is that the unexpected does happen, and you want to make sure that you've made the got the right plan in place, so that everybody can move on with their lives as best they can.